talked about. And one of them is that you can abridge qualified immunity in certain areas. So qualified immunity is the idea that you're not liable to civil suit if you don't do something bad that has specifically had a precedent in law. So you could do something bad, but as long as nobody else has done the same exact bad thing before, you're not subjected to civil liability. You could curb that.
Explain that again?
It's a little complicated. So qualified immunity generally means that if I do something bad, then as a police officer, if I act within the scope of my general reasonable authority, you can't sue me for it. The actual way
if you do something bad, what if you shoot somebody while you're operating?
So the reason that qualified immunity, as currently understood under Supreme Court doctrine, is too broad, is because that the standard used to be you would have to act as a reasonable police officer. If you acted as a reasonable police officer and you took a reasonable action, right? Somebody went for their waistband, they had an object in there, you didn't know if it was a gun, you shot them, right? You wouldn't presumably be suable because that's still reasonable. You track a guy down, you shoot him in the back, and then you plant a gun on him, that presumably would be suable, right? He'd be personally liable. So the way that Supreme Court has done this is they broaden qualified immunity to such an extent that you can still, bottom line is you can still get away with some bad stuff and not be sued for it. So that needs to be curbed. That's one thing. Second,